Thank you. Thank you. That reminds me to remind you that this will be recorded. So anybody who is unable to attend, you can we'll make the recording available for you to share. And most of you at this point, I think, know Av Harris, the new communications director for the courts. But Av, you do have a captive audience here. Is there anything you'd like to share about the communications office?
Very quickly, I just wanted to thank all of my partners for really bringing this program together today. I think it's going to be a very interesting program, and I'm so glad that so many members of the media and also from the judicial branch, court personnel folks have joined today. I think we have so many areas of overlap or intersection where the work that we do, we intersect with each other, and I think this is it's a fascinating program, and so we hope to do more of these and really be informative. Just so that you're all aware, I'll be helping to uh, do a little bit of logistics when we get to the Q&A part of this. You can submit your questions in the chat, and I will go through and curate those, and I will ask those of the panelists. So feel free to put those in the chat when the presentations are going. And then just very briefly, for anybody who doesn't, know me at all, I actually spent the first 12 years or so of my career as a journalist, starting here in Concord at New Hampshire Public Radio. Covered a lot of breaking news and, international news stuff, not over my, 10 to 12-year career in journalism. And then from then on, I've been doing communications work and policy work in state and municipal government. A couple of years for Washington, D.C. based nonprofit called the Concord Coalition. But I'm very, very happy to be here in Concord, working at the judicial branch. And I do enjoy working with all the members of the media. I do really try to get all of the information that's asked. And I know that sometimes we can't get everything that everybody wants, but we try our best to get all the information people are asking for as quickly as possible. And I think so far, since I've started this particular role in September, I'm really pleased to really see the collaborative, environment we have going. I think this committee, overall is a great venue for discussing matters that come up. So thank you very much. And I am happy to, if anybody wants to message me directly, who doesn't have my contact information, I'm happy to give it to you, but I am always available if people need anything or have questions.
Okay, thank you, Av. And we've got a great program for you this afternoon. Greg Sullivan is going to be our leadoff hitter. And as one of New Hampshire's preeminent media lawyers and president of the New England First Amendment Coalition, Attorney Sullivan will give us a 15 to 20-minute overview of what every working journalist needs to know about libel law. He'll be followed by Sig Schutz of Freddie Flaherty, who will take a deep dive into a New Hampshire case that was recently in the headlines, Eric Spofford versus NHPR. Attorney Schutz represented NHPR in that case. We'll also hear from Bill Chapman from Orrin Reno, who did some work with the NHPR newsroom while they were working on this story, and he'll also be part of our panel discussion among our legal experts. Following the two presentations, we'll have a panel discussion with Judge Mark Howard, who is a Chief Justice of the Superior Courts, and Attorney Katie Sullivan, who has recently defended libel cases in New Hampshire. Following the presentation by our legal experts, we'll have a Q&A. As questions occur to you, just put them in the chat. I will be keeping an eye on it, as he said. And if you have a question for a specific panelist, if you could note that as well, that way we can direct your question to the right person. That Q&A will run till about 12:55. Then we'll flip the focus from the courtroom to the newsroom, and NHPR News Director Dan Barrick will share some of his hard-earned wisdom from the Spofford case, and specifically how newsrooms can anticipate the challenges of difficult stories and put themselves in the best position to defend themselves and their work if faced with a legal challenge. And Anne Marie Timmons, the senior reporter at New Hampshire Bulletin, will then share her insights on how reporters from smaller news organizations who may not have lawyers on speed dial can protect themselves. And Dan and Anne Marie will also do a Q&A following their presentations. We have to get this all done by 1:30. So without further ado, let me turn it over to Attorney Sullivan. Take it away.
Howard, thank you very much. Justice Bassett, thank you very much. Thanks everybody for being here. Good afternoon. To teach the elements of defamation, libel, and slander, and a little bit on privacy in 15 to 20 minutes, we're just going to hit the highlights, which to me are the elements of libel law. It all starts for me with the First Amendment, where we have the freedom of speech and press. However, Laura Simoes. Well, there we go. However, there are governmental and societal interests that sometimes crash and clash head on with our rights to free speech and free press. And among those interests are protection of reputation, which we get from the Eighth Commandment, handed down from Moses to England to the United States. Privacy is another interest that will clash and crash often with our right to know and our right to exercise our free speech rights. Defamation consists of a false statement of fact. Those words are highlighted for a purpose that seriously harms someone's reputation. These are the four elements of a defamation case as given to us by the Restatement of Torts, which you can get on the internet, Restatement of Torts second. So it's a false and defamatory. Defamatory means injurious to reputation. Statement of fact concerning a third person. It has to be unprivileged, and we're going to talk a little bit about what privileges apply here. It has to be negligence if it's private, plaintiff will see, and either there has to be special harm, which means people won't associate with you or you lose money, but you don't need that special harm if it's defamation per se. Simple definition again is it harms the reputation or lowers them in the estimation of the community. False defamatory statement, alleged fact, communicated to a third party, no defense. There are only four defenses to a defamation action. Truth is the big one. That's what we seek to publish. Privilege, we're going to talk about. Opinion can be a tough one, distinguishing between opinion and fact. How do you know the difference? Difference is a fact can be objectively proven as true or false, whereas there's no such thing as a false opinion. The last one is hyperbole. I tell newsrooms, if you're going to defame someone, do it in an extremely big way. So you have now that's a joke, stemming from the case of Jerry Falwell versus Hustler magazine. So we have two kinds of plaintiffs in a defamation suit. We have a public plaintiff. And when we do, based on the New York Times v. Sullivan case, it has to be shown that the publication, the publisher either knew that the statement was false or at least acted with a reckless disregard for the truth. A reckless disregard for the truth is evidenced when the publisher publishes despite entertaining serious doubts about the truthfulness. And by the way, when I say publication, I'm publishing right now. We publish when we speak, when we type, when we write. Again, if it's a private plaintiff, all that plaintiff has to show is that the publisher was negligent, i.e. failed to act as a reasonable journalist under the circumstances. Now, defamation per se is when you don't have to prove that special harm. You don't have to prove people were deterred from associating with you or that you lost money as a result. Now, when we're writing a story or publishing a story in a newsroom and we come across these 4 areas, that's when we have to go back and I call these red flags. If we're writing that someone has committed a crime or is guilty of serious sexual misconduct, let's go back and check our sources. Let's get more than one source. Let's make sure we talk to the person who's being spoken about or written about. Criminal activity, loathsome and communicable disease. That when COVID first hit, I thought it might fit into the category. If you said someone had COVID and they didn't, was that defamation? Nowadays, I think we can take COVID off that defamation shelf. But there are loathsome disease and communicable diseases that if we tell people that this other individual has them and it's false, we can be liable for libel. That's Liable for Libel. This is a tough one. Communicating that someone is not fit for their trade or profession, whether it's nonprofit or not. You know, that judge can't even read. Serious sexual misconduct. Now, even if it's not defamation per se, if there is special harm, liability attaches. This is probably the trickiest concept to me anyway in defamation law. You can be liable for an opinion if you imply that you know facts that are defamatory that you're not disclosing. I'll be quick on this. The mayor is a bad alcoholic. Trust me, I've spent time with her every day for the past 60 years. Trust me, she's a bad alcoholic. I'm implying that I know things about that mayor that the public doesn't. But if I say the mayor's a bad alcoholic, trust me, I've spent time with her for the past 60 years, and I know that every Thursday she drinks a half a glass of beer. What a bad alcoholic. Now I've disclosed my underlying facts. I'm not going to be liable. They're going to say, that lawyer's a nut. This is a very important one for newsrooms and any journalist. Just because it was published in the Los Angeles Times doesn't mean you can repeat it. And that goes all the way through many channels. I'm going to talk quickly about privilege. Judges, attorneys, parties to litigation, witnesses, so long as it's in connection with that judicial proceeding, they can defame. The president, the governor can defame without liability. Members of Congress and local legislators can defame. They're privileged. Husband and wife, privileged. I'm gonna have to blow through these quickly, I know, but they are important when publishing. If someone is publishing and it's information that's important to that publisher, and it will be in service to that lawful protection. Now, they could be wrong. They may defame someone, but if they're not doing it intentionally, it's privileged. Information that affects the interests of a third person, and we transmit it to someone who has a legal duty, who can help. Sufficiently protecting a public interest. You can communicate the defamatory matter to someone who's authorized or privileged to take action if that defamatory matter is true. I believe my neighbor is neglecting and abandoning her children. I may be wrong, but I had a good public interest to protect me with a privilege. Most important one for news media is the fair report privilege. But it's important to note that what you're repeating had to be said at an official meeting, a press conference, for example, a town meeting, and you have to repeat it or at least give a fair abridgment of what happened. If the chief of police says there's a warrant outstanding for Joe Jones at a press conference, you can repeat it, even if that's false. However, if the chief of police tells you that at the diner Saturday morning over breakfast and you publish it and it's false, you can be liable. That's not fair report. Famous case, Bose Radio, which I love. The publication said that it was a terrible music machine. The music bounced off the walls. The music was just not understandable. Bose sued and lost on the opinion defense. Those are Dominion voting machines. We now know that corporations can be successful in their lawsuits, even if it's a nonprofit organization. Partnerships can sue successfully for defamation. Groups of people cannot, unless the group is so small or the circumstances indicate there's a particular reference to a particular member. All Boston cops are corrupt. Lastly, I've been asked to speak very quickly on invasion of privacy, which newsrooms and publishers can do. Question becomes, how far is too far when covering the news? There are only 4 kinds of invasion of privacy. I wish they'd let Judy Meyer in. She's on my screen. 4 kinds of invasion of privacy: public disclosure of private and embarrassing facts. This fellow's embarrassed. Intrusion upon seclusion. Sneaking into the restroom and looking under the stall with your periscoping camera. Intrusion upon seclusion. False light invasion of privacy is a tricky one. Most of you who are not as old as Bill Chapman and I may not know who Warren Spahn is. Warren Spahn was the world's best baseball pitcher, pitched for the Boston Braves in 1939, 1940. Greatest pitcher, one of the greatest pitchers in baseball history. But when World War II broke out, he joined the army. He fought in Belgium. We'll talk more about it in a minute. And the last type of invasion of privacy is misappropriation. There's a lawsuit pending now. McDonald's Corporation, which many of you have heard of, is suing Mr. Charlie's, which many of you have not heard of. But Mr. Charlie's food is all vegan, but it's all designed to look like McDonald's. McDonald's is alleging. Private life publicity, it's offensive to a reasonable person and not legitimate concern to the public. 1954 in Alabama, this woman came out of the fun house, stepped on a button, the wind came up and blew her dress up. This picture was on the front page of the county newspaper. She sued for publicity given to private life, and I don't think she'd win today, I believe. But this was pre-Madonna. Madonna was a woman who made wearing underwear on the outside popular, I think. And this woman got $18,000 from the jury in Alabama in 1954. I'm not sure how much that would translate into today's dollars. Intrusion upon seclusion is not all that difficult. Jennifer Aniston likes to sunbathe topless in her friend's backyard. There's a 6-foot fence giving her some privacy. What she doesn't realize over and over is that we now have these things called drones. And in her case, there was a 7-story apartment building next door that people were out on the balconies taking her a picture, which ended up in magazines. She sued, she lost. She did not have a reasonable expectation of privacy. This is Warren Spahn on the bottom left in his army uniform. That's a false light on top of him. When Spahn fought in the war in Belgium, he was injured. He got a Purple Heart, came back, started pitching. Fellow decided to write a book about his life, and he wrote that he was injured on the battlefield, taken away in a stretcher in an ambulance, and awarded the Bronze Star. All of that was false. He was wounded. He walked to an infirmary tent, was treated, back to the battle, back home to play baseball. And the difference between false light invasion of privacy and defamation is that false light invasion of privacy can enhance your reputation, whereas defamation, to be recoverable, has to damage your reputation. Again, you have to be a reasonable person, and the actor acted recklessly. In this case, the author of that book never even spoke to Warren Spahn. appropriation of name and likeness, one of my favorite cases. I always say if I want to start a root beer bottling company in New Hampshire, I can't call it Bruce Springsteen Root Beer without his permission. In this case, there was a fellow named Johnny Carson. Some of you know who he is. If you don't, he was Jay Leno and David Letterman rolled into one, hosted The Tonight Show. And every night his cohort, Ed McMahon, would come out and say, "Here's Johnny." Fellow in Boston decided to name his porta potty company Here's Johnny. Johnny Carson sued him successfully. He had to change the name of his company. So some websites, the Loeb School, NEFAC, of which Howard mentioned, I'm the president of. Reporters Committee for Freedom of the Press has a tremendous website, which Bill Chapman has contributed to over the years. That's my email address. I'm always glad to field questions. I went so fast. Laura Simoes has these slides, and anyone's welcome to request them and receive them from Laura Simoes. And just to end, I know my time's up. William O. Douglas, one of my all-time favorite judges, tells us that even when things seem seemingly unchanged, we must be aware of our rights being trampled upon. Thank you all.
Greg, thank you for that heroic effort at turning your hours-long presentation into a digest, and I'm sure there'll be plenty of questions for you. A reminder to everyone to please put questions in chat. And now let's turn it over to Attorney Sig Shoes, who is going to talk to us about the Eric Spofford v. NHPR case. Attorney Shoes.
Thank you very much, and thank you for inviting me to participate in this panel. I have been a member of the New Hampshire Bar since, I think, 2005, but I'm primarily in Maine. But it's a privilege to be asked to participate here and talk with you a little bit about what happened with NHPR. Like so much journalism, it all started with a tip. Eventually, multiple sources told Lauren Shulgin at NHPR that it was an open secret. The founder of New Hampshire's largest addiction treatment network was sexually harassing and assaulting women, allegations that he vehemently denied, but multiple sources insisted that he had engaged in a pattern of misconduct toward patients in recovery at his treatment centers and also employees, some of whom were also in recovery. And over the course of a long and careful, many-month investigation, Lauren Shulgin at NHPR cultivated sources willing to come forward. Some were off the record, others were on the record or partially on the record. When I say partially on the record, I mean a source that was willing to allow his or her voice to be used, but who had asked to be de-identified so that their name wouldn't be broadcast or associated with the reporting. But there were, as I mentioned, on the record sources. Key sources on the record included the company's former chief operating officer, the former director of spiritual life, who co-wrote a book with the owner of the business, and even the company's former HR director. And, consider that. I mean, how often does a company's human resources director come forward and confirm and go on the record that an employee had been victimized by the company's owner and founder, and she had notes. And I'll say the nice thing, I typically represent newspapers. I represent 5 daily newspapers and about 30 weekly newspapers as newsroom counsel. But the nice thing about defending a defamation lawsuit against a radio station is that the reporting's on tape. A source can always dispute a reporter's memory or even the reporter's notes, but a tape recorded interview with the source, not so easy. And even in one instance in this course of this story and defamation lawsuit, a source tried to kind of, under duress, voice regret and sort of present a quasi retraction of what he had said. What he had said, among other things, is that the founder of this addiction treatment center should be shamed shunned, and probably prosecuted. And he compared him on the record to Harvey Weinstein. This was on tape, and it was actually played as part of the reporting. So there was no backing away from that. So we've got a powerful New Hampshire business owner, well known, very wealthy, politically connected, claiming that this reporting by NHPR was fabricated. He hired a prestigious Boston firm, Todd & Weld. They filed a 100-page complaint with 200 pages of exhibits, claiming that it was all invented as a malicious smear. And then just a month after a defamation lawsuit had been filed attacking NHPR's journalism, other attacks began and were launched against NHPR. And I'll just share a warning that these images contain depictions of hate speech. I'm proposing to show them, or I'm going to show them to you to illustrate the severity of the threat. And if I can, I'll just share screen for a minute to let you see this. There were actually 2 rounds of vandalism targeting NHPR. This is the first round. I think Dan Barrick, who's on, this is one of these photos of the front door to his house in Concord. So this is a month after the lawsuit had been filed, and then a month later there was a second round of vandalism. In the photo on the left, with just the beginning, that's Lauren Shulgin's house in Melrose. The front window of her house facing the street had a brick thrown through it. So the reporter's house was vandalized, the editor's house was vandalized, and I use vandalized. That really does understate it. I think this is really more in the nature of terrorism. Really the reporters were being terrorized. NH law enforcement, New Hampshire law enforcement. So this is 2 states. These are coordinated attacks against, again, the reporter, her editor's house. The reporter's parents' house was attacked. Even her former house was vandalized in much the same way, with spray paint of the same color with the same word. New Hampshire law enforcement at first urged NHPR to keep all this under the radar, not to report on it. They argued that disclosure could interfere with an investigation. We had some reservations about that approach, but we're prepared to entertain it until the second round of vandalism occurred in Massachusetts. Massachusetts authorities took a very, very different approach. And the Middlesex County District Attorney actually held a press conference, which she showed images that had been captured of one of the vandals, and basically said that attacks against journalists will not stand, that they would put the full weight of her office. I think Middlesex County is larger than the entire state of New Hampshire by population. It's larger certainly than the state of Maine by population. She indicated she would put the full weight of law enforcement behind an investigation, that these attacks would not stand, and attacking journalists for exercising their First Amendment rights was intolerable. And they really held true to their word, because the FBI and the Massachusetts U.S. Attorney's Office engaged in a very significant investigation. And the federal crime they were looking at was the federal interstate stalking statute. And ultimately that investigation bore fruit. Law enforcement never connected the vandalism, or at least has not yet connected the vandalism, to the plaintiff in the who filed the defamation lawsuit, Eric Spofford. But they did connect the vandalism to NHPR's reporting about Eric Spofford. And they've indicted a close friend of Mr. Spofford and 2 thugs that he hired. This is according to federal criminal documents. They've been criminally charged. I think the thugs have actually pled guilty at this point. That investigation continues. So briefly back to I used up a lot of time on that, but let me get back to the libel case. NHPR filed a motion to dismiss, arguing that Mr. Spofford was a public figure, and that he had not alleged facts despite the 100 pages of allegations, despite the 200 pages of exhibits. NHPR argued that he had not alleged facts sufficient to state a claim that NHPR had acted with actual malice. That's the New York Times versus Sullivan standard of fault that applies to claims against public figures. So this isn't malice in the terms of a punitive damages or a desire to do evil, or sort of an evil desire to hurt somebody. This is actual malice, which is defined as knowing or reckless disregard of the truth or falsity of the statement. Judge St. Hilaire in Rockingham County Superior Court held a hearing. Judge St. Hilaire determined that Mr. Spofford, the owner of this treatment center, was a public figure. He also determined that the complaint did not sufficiently allege actual malice, and wrote a thorough and detailed and entirely correct, I'm biased, but entirely correct decision dismissing the case. Then things got a little unusual. And for the libel lawyers will recognize this, but I think journalists can understand, of course, the judges as well, but the journalists, this is really unusual. Mr. Spofford moved for leave to conduct discovery even after his case had been dismissed. And he essentially argued that he was in a catch-22 situation. He claimed that the allegations about him were categorically false and fabricated by NHPR, and that he couldn't prove that NHPR knew that the allegations were false without access to information about what NHPR knew and when it knew it. So he argued that the judge should give him the benefit of the doubt and an opportunity to do some limited discovery to find out what NHPR knew about him, so that he could go back and amend his complaint to make more, to add additional allegations that might rise, that might allow him to clear the actual malice threshold. We thought that the judge would deny that motion, given a body of precedent, mostly in federal courts. Well, there were a couple, I think, unreported New Hampshire state court decisions, but there was precedent supporting dismissal for failure to plead actual malice. That does happen fairly routinely at this point. Judge St. Hilaire took a somewhat different view. He actually granted that motion and allowed limited discovery, but he allowed it only in very specific ways. He ordered that NHPR provide to him and him alone for review under seal in chambers. It's called in-camera review. Certain categories of NHPR records, interview transcripts with some of the key sources, internal notes, and so forth, that might go to this question of whether NHPR acted with actual malice, as the plaintiff argued. Judge St. Hilaire indicated that he would review this information in camera. He would decide whether any of this information contained any suggestion that NHPR had acted with actual malice. If so, he indicated that he would identify that information. He would allow the parties to further brief the issue, and then potentially he would turn that information over to the plaintiff. And this included off-the-record sources, anonymous source information, internal newsroom communications, and so on. Ultimately, if plaintiff navigated that gauntlet, plaintiff might, per Judge St. Hilaire's order, get access to these materials, be in a position to amend his complaint, and then potentially proceed with the lawsuit. Obviously, we weren't thrilled with this order.
Sig, I hate to interrupt you.
Out of time.
Yeah, you are at time, but I don't know if you can wrap it up in a minute or so, and then
right.
Obviously, right. I'm sure people will have more questions for you. But
okay, all right. I'll ultimately NHPR delivered to Judge St. Hilaire, I think, in the neighborhood of 4,000 pages of records. And keep in mind, this was reporting by a reporter and a team of reporters over a course of 18 months. He reviewed those records and issued a terrific order, finding that there was not only no evidence that NHPR had acted with actual malice, but the records demonstrated that NHPR had acted professionally and with great diligence. And I'll say NHPR actually held back and did not report additional information about Mr. Spofford, and I'm sure that was part of Judge St. Hilaire's calculus in determining that NHPR had acted prudently and professionally. And I'm paraphrasing his findings, but that is really what he wrote in his order. So it was a real vindication, ultimately, of NHPR's reporting. Ultimately, that ended the case. We did get a e-discovery cost shifting order for the plaintiff to pay about $30,000 of NHPR's expenses for having a vendor go in and collect, tens of thousands of communications, Slack messages, electronic discovery, and other records. And I guess one lesson, and I'll just wrap it up here, I guess for attorneys and maybe judges, is just to understand how expensive and time consuming it can be to deal with these vast quantities of electronic records and information when you've got to get a vendor to go in, and it's just very daunting and time consuming to deal with. But we did actually ending the case with a check. I don't know if Dan Barrick has a copy of it on a frame somewhere at NHPR, but from the plaintiff for about $30,000. It was a privilege to work with Dan, you and your team, and Lauren, and I'm just glad the good guys won and there's been some justice in the criminal justice system.
Thank you, Attorney Schutz. Really interesting stuff. I know a bunch of questions I certainly have, and I imagine other people on this presentation will as well. Please put those into the chat. Now we're going to turn to our panelists, and maybe I'll turn first to Bill Chapman, only because Bill was also involved in the pre-litigation part of this story. And Bill, you said you had offered some guidance regarding the use of confidential sources and New Hampshire law surrounding that. And I'm sure people would be interested in that.
Thank you, Howard. I got involved very early on. I'm a board member of New Hampshire Public Radio and have been for some time, and volunteer my time in something like this. I simply told Lauren at the outset that she couldn't promise confidentiality to sources who requested it, but what she could say, and this is fairly common within the industry, that a reporter would protect a source up until the point where a court, and in our instance, the New Hampshire Supreme Court, would have ordered Lauren to disclose the source. But the way the story played out, the number of sources that she had, that didn't become necessary. And I'll stop my comments there because I don't want to interrupt Q&As that the reporters might have.
Mm-hmm. Judge Howard, you had expressed some interest in the issue of privacy. Did Greg Sullivan cover that, or were there other things you thought would be helpful for reporters to know?
No, Greg covered it very well. I did have one question that's probably either for Greg or Sig or maybe even Bill Chapman, and that is Greg had made mention of repeating stories that other publications, say the LA Times does a story and then the local paper wants to republish that story. Is a disclaimer that by the local paper that all you are doing is republishing, you haven't verified the story yourself, does that protect you?
I'd say no.
I see that quite often now, these types of disclaimers.
Yeah,
You can't.
I think Greg, I agree. I don't think that protects you. There is another wrinkle if you use ChatGPT for anything or tried it out. Now they have a disclaimer at the bottom of ChatGPT, and there's, I believe, a libel lawsuit against ChatGPT that someone's trying out now, I think in Georgia. So, I mean, this issue of disclaimers, I think it can be relevant in certain circumstances, but for like a traditional news outlet, I don't think that's not going to fly.
I agree.
Thank you.
All right, thank you.
And Katie, I know you have fairly recently argued some libel cases in the New Hampshire courts. As you've been listening, is there things that you've heard that you might want to expand on, or questions you might have?
No, not on any of those specific points that have been made or addressed. My most recent libel case with the New Hampshire Supreme Court is still pending there. It was argued over a year ago. But it addresses sort of a whole separate set of issues, which may or may not come up in the next panel discussion or in question. So I'll wait.
All right. Av, we can turn it over to you for questions.
Well, thank you very much, and thanks to our panel. I would kick it off with the first question, because I'm certainly noticing this a lot from my vantage point, and I'm sure many here, in the media, would probably share a similar perspective. The definition of who is media and freedom of the press and what does the First Amendment protect. From my vantage point, it's becoming very murkier, much more murky and fuzzy as to defining who is protected under the First Amendment, under freedom of the press, because everybody seems to be able to call themselves a journalist just by posting things on social media. So I'm wondering if each of those who spoke, Attorney Sullivan, Attorney Schutz, even Judge Howard, or you as well, Katie, if you can reflect on how the impact of social media and the ability to instantly, put something out there for many, many people without some of the filters, right, that all news organizations will have, the filters of editors and, checking for fairness, checking for accuracy and things like that. What is the impact of social media and people's ability to comment publicly on things? How has that impacted, this whole concept of libel and defamation?
I'm going to jump in and say, with respect to the basic elements of defamation, for example, not at all. As I said, a publisher publishes when they speak or write, whether you work for a recognized news organization or not. When I think of the difference between the public and the press, I think of, okay, well, at least courtrooms give a few extra seats to people who say, I work for, let's say, the Union Leader or the Concord Monitor. But other than things like that, to me, there is no distinction between the organized news media and other publishers. I'm just going to put in a quick swipe to say, apparently, the administrators and president of Dartmouth University don't understand that student journalists are distinct from student demonstrators. I say that because they arrested 2 student journalists the other night.
If I could address that from sort of a different angle, I know that the prevalence and popularity of social media has caused a lot of conversation and concern about who is now a public figure versus a private figure, when so many people go viral. And I'm aware of legislation in Florida, and I believe it exists in other places, but there's a Senate bill and a House bill out of Florida that are both died in committee as of now. But in January, they were trying to, it was the purpose of the bills was to make it defamatory per se to accuse someone of racism, sexism, homophobia, transphobia. And in the bills, they had also tried to limit who would be considered a public figure, in excluding non-elected or appointed public officials. And I don't remember exactly what the text of the bill was, but it wanted to exclude from the definition of public figure anyone who had been thrust into the public light by defending themselves in a viral video, and giving interviews. But basically, when there were controversies over someone accusing someone else of being racist, sexist, homophobic, if the dispute and the defense went viral, that person would be excluded from the definition of a public figure by that legislation, which has failed, but they keep trying to bring it back. And I know that there are attempts in other states as well.
Yeah,
How do you define viral?
yeah, I don't know, but I was just going to say on the impact of social media. I mean, I agree with you, Greg, that these standards don't apply. The First Amendment protections we're talking about for free speech don't apply differently to the news media and private citizens or others. The same protections are going to apply. The issue, of course, for news organizations, they've got standards. They can make mistakes, of course, but they've got standards. They're professionals. They're diligent. They're trying to do their best to be accurate. But someone typing in front of their keyboard at home feels empowered to say anything, and that's a big problem because it really has coarsened the discourse and lower the standards of accuracy. And you get into there's Section 230 of the Communications Decency Act immunizes these social media websites that are posting all this stuff from liability. So you can't sue Facebook, but you can try to find out who posted, and the poster may be anonymous, hard to figure out who actually posted. They maybe not be collectible. There are a lot of problems. So a newspaper publishing information on their front page, yeah, they stand behind that, and they've got insurance and operations and all the rest. Well, Instagram and TikTok, and they're just allowing anybody to post anything freely with no accountability for any of that content. And then obviously they've also decimated the ad revenues of traditional news media and taken a lot of that revenue. So it really is kind of an unfair scenario, both from a news organization standpoint, and then in terms of the public standpoint. The public is left with a lot of garbage, and no easy remedies, to shut that down.
All right, I'm going to go to next to a question, not directed at anyone specifically, but probably for one of the attorneys, and I don't know if Judge Howard, this might be one for you as well. This is from Ethan DeWitt. He says, my question is about New Hampshire's two-party consent law when it comes to recording. He says, I always try to ask for permission to record a phone call interview at the beginning of the call and to record the person giving consent, but occasionally I forget. How does an interview in which the reporter did not get the formal recording approval impact a potential defamation case down the line? Could the subject use it against a journalist to prove a bigger defamation claim?
Waiting for Judge Howard.
Well, the eavesdropping statute, which is what he's referring to, only requires the consent. It doesn't require that the consent be recorded. It doesn't require that the consent be in writing. So at that level, it seems to me it's a credibility contest between whether consent was given. And so obviously you want to have that recording, you want to have it in writing, but how would it affect defamation? I'm not, unless the other side proves that you did not, the fact finder concludes that you did not get consent, well, then it may affect your case. And there are statutory damages for that as well.
The only thing I would add to that is if the reporter realizes that he or she didn't get consent, go back and get it. That's right. The easy way to solve the problem.
Okay, so looking at the time, I think, Howard, we can probably move on to the next panel, and keep the questions coming in, and we will definitely get to as many of them as we can. But Howard, I don't know if you wanted to go ahead and introduce the next panel.
Well, next we have Dan Barrick, who is the news director for NHPR, and He's been referenced in some of the previous presentations, and he's going to share his experience and his hard-earned wisdom. And then Anne Marie Timmons from New Hampshire Bulletin is going to talk about working, in a smaller news organization that might not have the resources available to protect a reporter, and how reporters can protect themselves, which is always a good idea. And Dan, take it away, please.
Sure. Thanks, Howard, and thanks everyone else. So Amir and I were hoping that we could give, as Howard said, sort of take the conversation into the newsroom, and how some of the concerns and the legal reality that the attorneys discussed, how that can kind of play out and shape editorial conversations and decision making. I'll say first off, almost anything I know about how to manage difficult editorial decisions around legal matters, I owe to many conversations with Bill and Sig over the years. So I thank both of them for their help. When we were doing the Spofford reporting, we anticipated, once we decided that this was a story, that the tips that Sig described were worth pursuing, we also anticipated that there would be pushback or results from the published reporting that were going to be of a different order of magnitude. We knew that the person we were reporting on had a history of litigation, that he had deep pockets, and that our reporting would likely, put a lot of his business interests at risk. So the way I think about it now, we kind of divided our preparation and thinking about this into 3 stages. The kind of before you're like actually doing the reporting, the sort of planning for how you're going to undertake the story, the actual reporting process, and that includes, interviews, drafting, editorial conversations, edits, and then the post-publication, how do you respond once the publication is out there in the world? Pre-publication, we did a number of things. One was anticipating some kind of response, a negative response to the reporting that included but was not limited to a potential legal action. We thought about the ways that our reporter and other members of the editorial team could face pushback, and that included, obviously, a lot of it, the focus was on in the digital realm. So preparing ourselves by making sure everybody's social media was locked down, that they had 2-factor authentication. Lauren got a Google Voice number that she used to solicit tips, so that her cell phone number was not out there in the world and could easily be found. We secured, and I really recommend this for any newsroom that has the resources, we use the services of a Delete Me. Some people may be familiar with that, but it's basically a service that a lot of newsrooms use, where it essentially you're dealing with a third-party service that scrapes the internet and clears identifying information about you. So, data brokers that might have your home address or your phone number or your email address or your kids' names on there. We made all of our social media profiles private so that nobody could find, pictures of me and my kids on there. We also thought about just how personal this kind of pushback could be, and thought about ways that we needed to support the reporter at the center of this, that her name is going to be in the reporting, and that being, accused of defamation, being the target of online trolling takes a personal toll. And we built into our editorial process a willingness to be open about the impact that can have on the reporter as a person, and making sure that, these are not conversations that I think most newsrooms are comfortable with, and I certainly wasn't before this, but, before every big edit, check in, how are you feeling? What do you need from your editor? Are you getting enough time off? How can you separate yourself from the psychological and personal toll that intense public criticism of your work can yield? And finally, we sort of adopted the practice, both, with the advice of Bill and Sig, of not changing our normal routine as an editorial team. So if you record notes from every interview in a Google Doc, keep doing that. Don't stop your note-taking practice. That said, you don't need to adopt new practices. So if you typically, keep those by hand, you can feel free to keep doing that. You don't have to suddenly change that. But don't either start, don't do anything different. And don't feel that you need to do that. During the reporting process, we made sure, as kind of Bill said, that we thought really carefully about before every conversation with the source who might seek anonymity or some degree of protection, that we were clear with them about the risks that they face by talking to us, the effort, the steps we would take to protect our identity, but the limits of that. We made clear to them that we plan to contest in court any efforts, but that we couldn't guarantee, universal anonymity. That was really important, I think, in being clear with the sources, but also building trust with them that we had thought through this, that we had a plan. Also, during the leadership, the reporting process, an important thing was really communicating clearly with the station's leadership, the CEO or publisher, making sure they know that you're dealing with a difficult story, getting their buy-in and support, so that the last thing you want to be worrying about is a CEO or publisher who doesn't have faith in the reporting, is concerned about, you want them to have, they bear a different level of concern or risk than the editor or reporter do, but getting their buy-in was really important. And then finally, after publication, we thought we had a plan for how to protect Lauren in the event of an online, troll attack. We did not anticipate vandalism. We will next time. But for instance, the day her first story ran, we had one of her fellow reporters kind of take over her social media, so that if we it didn't really come out, it didn't happen this way, but in case, an army of Spofford fans started bombing her Facebook or her Twitter account, that she didn't have to wake up to that another reporter could kind of just read her feed and say, like, hey, you might just want to step away from this. And then really having a clear structure for how we would manage any response. Who editorially would respond to criticism of the reporting, who would be our main liaison with our attorneys. That kind of clarity just kind of helps everybody feel calm. Sig talked a lot about the legal response that, once the lawsuit was actually filed. But hopefully that gives you a little bit of sense of just kind of some of the steps within the newsroom that we felt we had to take to both assure ourselves that our reporting was solid, that it was all documented, and that we were protecting and preparing for the toll that this was going to take on the members of the editorial team. The last thing I'll say, too, I should have said this earlier, an important thing was, in addition to not doing anything differently, you do just want to be aware that anything that's in writing, that's communication between the editorial team. So that is everything from emails between a reporter and an editor, Slack messages, text messages, comments in a Google script, in a script in a Google Doc, are potentially discoverable in a lawsuit setting. So I know, in a lot of newsrooms, there is the kind of gallows humor, and it's not, we're all trying to get by, but you want to make sure any communication, even in a joking manner, could not be interpreted, but by a judge as meant to cast aspersions on the subject of reporting, casting doubt on the veracity of the sources we're using. As Sig said, we had to turn all that over to a judge. We knew that we had no doubt that we had done our due diligence. We had double and triple verified every source, but any member of a newsroom knows, you might in passing make a joke or something like that. You really want to make sure that you're thinking, what would happen if all of our communication was in the hands of a judge and made public? So that's part of the process as well. But that's just a little bit of how we handled it. I know Anne-Marie has her own experience in these matters as well. So.
Thank you, Dan. I really appreciate that discussion of discovery too, and hopefully we'll have time to go back to that as well. And Anne-Marie, the floor is yours.
Thank you. I'm so glad to be here. I'm glad to see all my fellow journalists. So I'm going to talk a little bit about how I protect myself, just maybe some tips I've learned, some the hard way. Really, it's all about good habits, and good habits are a good way to back up your story. They're also a good way to have a good reputation as a responsible journalist. So if you do find yourself in trouble, you do have that reputation. You're not someone coming in who's known for eavesdropping or being sloppy with facts. So really good habits, reporting habits are important. And that's for the tiny, tiny stories and for the big stories. And so some of the things that I do is like my colleague Ethan mentioned, I record interviews and then when we start, I'll say, okay, can you hear me? It's sort of like a script. Can you hear me? And it's okay if I record, just to have that, that on a tape. I think when I started recording, I was nervous people would say no, or they would start to be careful in the way they talked. I haven't found that at all. So if you're nervous about that, I really have never had anyone say no. And as the conversation goes, even in like as it is in real, person to person, it becomes very comfortable. And I haven't found them to be like freeze up because of it. Source what you say. There was a saying in the Monitor newsroom, if your mother tells you she loves you, you need a second source on that. And that's always stuck with me, because your best defense against libel is for it to be true. And so stick to what's true, stick to what you can source to someone or something. And so record your interviews. That's what I do, whatever practice you take. I also am probably an overtaker of notes. And so I have Google documents that track what I do. Left voicemail at 2 p.m., tried again at 3 p.m. I keep that kind of record just in case something happens, because my experience is you can be sued over a story you didn't expect. That happened when I was at the Monitor. It was a Friday afternoon. The AG's office put out a press release about a man who was convicted of really, setting up an elder that he was supposedly caring for and stealing all our money. And I think we wrote that pretty much off the press release because it was a Friday afternoon, and he sued from prison for $1 million. And that went away, but it took a lot of time and money to make it go away. And because I had kept my notes, I kept that press release, and I was able to say, this is how we handled it. It went away sooner maybe than it would have, but it was an expensive and painful process, where I was questioning about everything from what medication I'm on to, how long I've been a reporter. So it was just not a situation you want to get in. So again, you can't always avoid it, but good record keeping or good reporting can help you there. When I'm asking for someone for a response, whenever possible, especially on a big story, I will try to let them know if I can the night before. Like, I'm going to call you tomorrow. This is what I'm working on. This is my deadline. Can you please be ready to answer that question? Email them again in the morning. I do try to email because it's a good record. I email them again and say, just wanted to remind you, I am working on this. My deadline is such and such. If I haven't heard from them, I'll say, I'm publishing in an hour. We're kind of getting down to the wire here. And again, I'm keeping all this documented in my Google Notes. And then probably the last resort, if it's really a situation where I want to make sure I've made sort of over attempted to reach them, I'll say, if I gave you another hour, would that make a difference? Would you be able to comment? Or if I gave you 2 more hours, like whatever you can do, because I always say, I don't want to be first and wrong or first and sloppy. I'd rather be second on a story, as hard as that is for me, and get it right and really get it solid. I see this sometimes more frequently now, and this is something I really try to avoid. And I think I know what it comes from. It's, you have 3 people now in your newsroom and you're trying to churn out stuff really quickly. I'll see say something like, oh, someone didn't mention why they think that way or why they're alleging that, or you don't have time to go check it out. So you'll just, write around it when it was something you could have found out. So I just would be careful of that. And again, I think I know where it comes from because we have too much to do and so little time to do it. But just be careful and mindful of that. When you write something, make sure if you were in that position, wouldn't you want to have the chance to say something or have the facts, borne out? You don't just go with what one person said. You really want to just go the extra 10 miles to make sure you have it right and sourced. And on sourcing, I record the interview, obviously. I do my research as much as possible. I try to nail things down with actual documents that I've gotten through right to know request, or I've challenged, sealed court records, everything from a pretty small case to a death penalty case. And, on the fly in court, was able to get those records either unsealed or prevented from being sealed. I've been hearing from some reporters that the Attorney General's office now is almost by default filing everything under seal when that's not allowed. So just because it's sealed, don't assume that it should be sealed or all of it should be sealed. So become familiar with how to file a right to know request and unseal a court record. And there's lots of resources on that, or call a reporter who's done it before for more guidance on that. Because you have a good chance of being successful. And the reason I like those primary documents is because it protects me. I also increasingly upload that to my stories, because as the media has increasingly poor reputation, deserved or not, you can point someone to see, here, it's not my word. Here's the actual document I got. Granted, if you spend any time reading comments on Facebook, you will realize no one actually reads your stories. They just share opinions. I'd also encourage you not to engage, even though I don't follow that rule, and then I regret it. So primary documents, because it will protect you, and it's just good reporting. Even if I don't think I'm going to get something by a right to know law, I file it anyway, again, to keep that record of trying to do diligent reporting. Sometimes I find that agencies want you to file a right to know law, because a right to know request, because it gives them cover. I just had this case this week with an agency, didn't mind if I had something, but didn't want to hear from the other party and be accused of just cooperating with me. So in that case, I just filed a right to know law, and it was agreement between us. A couple of cases that I wanted to just say, I've worked with Bill Chapman a lot, and like Dan, I learned a lot of this from working with Bill and Greg. There's just some things that have always been done and maybe shouldn't be. So in one case, the Judicial Conduct Committee, which oversees the behavior of judges, would handle their cases in private. You weren't allowed to go, even when it seemed like you should, and you weren't allowed to take any photos. It was just really sealed off. So, Bill and I worked, and we got those opened, and now they are opened. I've succeeded in getting into court hearings when competency of a defendant is in question. And it's been a case where I can sit in for these 5 minutes, but then I got to go out for 10 and come back in for 5. And again, to be able to write about that kind of issue from the courtroom, it's just safer and it's just more responsible, I think. And I want to talk about just one case I recently did. It was a boy was murdered in Laconia about a year and a half ago. The case has got no attention from the governor, not much from the Attorney General's office. And I was interested in it. And the grandmother was sort of suspected because this boy lived with her. There was a long court record of all the abuse he and his siblings had gone through. And the grandmother wouldn't talk to investigators, but I found her under a fake name selling by Facebook Marketplace. She was selling really bad paintings. I knew what her fake name was, and I reached out, and I didn't expect her to comment, but over the course of the weekend, we exchanged 80 messages on Facebook. So then I have a record of it. That's very solid. But I would go and I would make her say, like, this is who I'm talking to, but you're really this person, right? And I asked her again and again about that. She would talk about these horrible things that had happened to the child and then write LOL. And I would say, do you mean laugh out loud? Like, I didn't assume anything. And I just wanted to be really solid because she hadn't spoken to anyone else. And I knew the police would come looking for that record. And they did in the end. Bill had advised us that I would have to give that over. So I asked them to get a search warrant because I did not want to just hand it over. And, that was understandable. They agreed it wasn't a problem. I want to talk lastly just about vetting a story. What helps me is if someone really interrogates me on these really difficult sources, like, how do you know that? And how do you know this? And where's your source on that? And it's so reassuring as a reporter to have that kind of test of every single fact in your story. Because if you do it to yourself, you can overlook things. But what I do is when I'm writing a story like that, I'll just write a comment to myself and put the source for that fact in the comment. And so then it's there, or it's in my Google Notes so that I can quickly say, yes, that's the right source, and I'm going to read it again, and that's exactly what the person said. So just to have really solid record keeping for me, again, like Dan said, you don't want to start something new or stop doing something because that becomes suspicious, I think. But for me, I just source it, and then I write down all of that, and I keep it with the items in the story, because if you are challenged, I just think it's a lot better protection to be able to quickly say, this was my source on that, rather than be able to say, oh, I don't know what my source was, or to not remember what your source was. Just looking at my record here. Oh, the very last thing is we do make mistakes. If you're called on something, respond immediately, even if it's on the weekend, apologize, sort it out, make the correction very quickly. Again, this goes to, saving yourself potential legal problems. It's also the right thing to do. It helps your reputation in a small state as a reporter. So it's painful. It gives me a stomach ache when I get that kind of email, but the best thing you can do is to respond. Often people say, like, I can't believe you responded, thank you very much. And it really resolves that. You don't want to get them angry and then send them off to court to challenge you and go after you. So that, I guess I'll just wrap up there and leave time for questions if there are any.
Thank you,
Thank you.
Anne Marie and Dan. Really informative presentation. So we do have a question from Stephen Porter of the Boston Globe, and Dan, this specifically has to do with the NHPR experience. But I suppose the question might be for you or Sig or any of the attorneys involved in your case as well. Stephen's question is, given the protracted hassle and expense that NHPR dealt with in the Spofford matter, what advice would you have to help journalists not only win in the long run, but also find an early off-ramp to resolve or rebuff libel allegations? I guess I'll let you take that one, Dan, or if Sig or Bill or anybody who was involved with your case there has any advice.
Dan?
Well, I think if there was an easy off ramp in that Spofford case, we blew right through past it, and I wish we'd found it. I think the reality is, like, a lot of Anne Marie's advice is really good, and we try and follow as well. Responding to critiques immediately, documenting stuff, relying on written records. One thing that I didn't mention that is maybe in this ballpark, which we did, is, again, when you're anticipating pushback, denial, possible litigation, we were really careful and thoughtful about when it came to the point in our reporting when we knew we had to reach out to Spofford himself and seek his comment. And we really did bend over backwards to give him the opportunity to respond, to know exactly what we were planning to report, to give him the opportunity to respond to each individual allegation. We didn't just simply say, we're reporting some allegations, what do you say? We first sought to get an in-person interview with him. We were unsuccessful there. We gave him questions with a firm deadline, several opportunities. I think we reported this. He then came back and said he would only do an interview if he could tape it and it would be on his terms. And we sided against that because we did not feel it was in the best interest of, it was done in good faith, or that it was in the best interest of our desire, which was, one, to get his perspective on the record and let him share that, but also to clearly communicate to our audience, our findings and his response. And it risked putting Lauren in an unfair and uncomfortable situation. But we really did think really carefully about making sure there was no opportunity for him to accuse us of sandbagging him in print, not giving him an opportunity to respond. So that that's what, I guess, an answer to that question. One way to avoid in the first place is just making sure that you're not opening yourself to allegations of unfairness before you even go into publication.
Yeah, I think that's all well stated, Dan. I'll just add, I think, really in the NHPR reporting, if any of you are interested in it, I would highly commend, and it's award-winning, to check out NHPR's podcast. It's called The 13th Step. Apparently that's a well-known phrase in some quarters of the substance abuse treatments industry. There's the 12-step program. The 13th step is taking advantage of women in recovery. But you can check out their podcast wherever you get your podcasts. But NHPR showed its work in the reporting, in publishing the actual voices of the women making the accusations. So, part of our position was, look, listen to it. There are sources. They're on the record. They're in the broadcast. You can hear their voices. So I think there was an element of show your work. I will say the other piece of this was, in my view, the lawsuit wasn't about winning. It was never going to win. The lawsuit was about punishing NHPR, and even more so, silencing additional women and censoring them, creating pressure on others not to come forward. If you come forward, because NHPR wasn't the only one that was sued, 3 of their sources were sued. And the part of the point of the lawsuit was to attack NHPR, but to stop others from coming forward. And a whole episode of the podcast, the beginning of the podcast, I think it's episode 4, are the snippets of women who talked to NHPR and then said, you know what? Never mind. I've reconsidered. I can't risk this. I can't put my family through that. I can't be sued. One of them, part of the podcast, is a source who said, and then I heard about the vandalism, and it occurred to me that maybe I shouldn't have spoken with you about what he had done to me. And that's all on the record. And I'll say, the other point, I believe in New Hampshire, this did not pass in your legislature, but a lot of states have anti-SLAPP statutes. Maine just adopted the Uniform Public Expression Protection Act. It's the 7th state, I believe, in the country to pass that. It's a version of an anti-SLAPP statute that protects freedom of speech, and it provides for an early dismissal process and fee shifting. California's had that for a long time. That is a very powerful tool to deter what this case, in my opinion, was, which was a strategic lawsuit simply to punish the exercise of First Amendment rights. And the legal system did not have the tools to effectively deter that. So that I believe there was an effort. I think maybe Greg was involved, but I would highly commend those who are concerned and care about this to take another run at the legislature when appropriate in New Hampshire to get an anti-SLAPP statute passed.
I would only add one thing, and I think Dan implied it, Sig didn't mention it, but a well-done story, a well-sourced story is going to give Sig the opportunity, which he was too modest to mention, to file a motion to dismiss the case, shortly after it was filed. And that motion had a few permutations to it, but ultimately it prevailed and there was no trial.
So we just have about 5 minutes or so to wrap up. Anybody who's got questions, we probably have time for about one more. I do, listening to all the panelists today, one question I would have is, I think that, I will share, my own personal opinion here is that, there are reasons why the freedom of the press was written into the Bill of Rights and the Constitution, and the way in which the judiciary is described is written into the Constitution as well. I think an independent judiciary and a free press are both extremely important pillars upholding the rule of law in this country. We are in a very different period of history than we have been. So my question is for Dan or Anne Marie. This particular story with NHPR and Mr. Spofford, coming after you, and people facing vandalism and kind of personal assaults. Has there been any kind of chilling effect from those attacks on what you do as reporters in thinking about this? I know the easy answer is to say, no, we're not changing any practices, but have you talked to the reporters in your newsroom or other reporters at other organizations who may take a look at this? Because I think, Sig, your point is 100% right. The point of the lawsuit was to punish, the reporting itself and to send a chilling impact on those who might dare do something like that. Has there been any impact? Are we thinking twice about reporting certain stories based on what happened here?
I guess to your question, like, I'm not afraid to say, yeah, did like the vandalism spurred a real soul searching among our editorial team about the risks involved and the unpredictability of it, and how well, I know how to protect a reporter from mistakes they might make on a script, but I don't know how to protect them and their family from physical violence. I'll say we were very lucky and very supported by the station management. We talked about security and other efforts. But Sig was really instrumental in telling us that, in the same vein as, like, don't change the way you take notes. Well, just because you feel you might be under threat from a lawsuit, don't change it. Don't stop reporting if you still believe in the veracity and accuracy and of your sources and the importance of the story you're telling, and you have no doubts about its truth. Continue. And that's the sort of easier said than done aspect. But I think, and that's kind of what I was talking about at the beginning, where we know that, like, acts of vandalism directly at journalists is still very, very rare. But we had to be real about the toll it was taking on Lauren and the rest of the team, and being open and about talking about our feelings. And in editorial meetings, it's not common in newsrooms, and I'm not saying it should be in every instance, but we kind of recognized with some advice that helped us focus on the work. If we could sort of say at the beginning of an editorial meeting, how are you feeling? What's on your mind? How's everybody? What is everybody bringing to this meeting? We could talk about it, be open about it, and then say, okay, great, we've shared that, everybody knows. Now we can really focus on the work, on editing this script or talking about this interview. So that was one thing we learned along the way.
I haven't experienced anything nearly as awful and scary as what NHPR did. I probably don't think about this enough because it doesn't occur to me to stop. I've had people, I was writing about an individual who, they lived in a car down on Main Street, and his girlfriend, and he would, in his words, keep her in line with the baseball bat. And I wrote about that, and I depicted him as he was, and he did show up at my house with the baseball bat. And I think I reported it to the police, but it's awful. I just think, oh, that's part of doing this job. It's not the only time someone has showed up at my house. So I'm probably not a good judge. As I just went to Texas to report about the National Guard, I was petrified of the spiders and scorpions to the point where I thought about not going. But that doesn't stop me from doing it. But I wouldn't encourage everyone to think that way. In some way, it inspires me, because I feel like we have to tell these stories if other people aren't. If we're scared, how about other people? But again, my situation wasn't as bad as what NHPR went through. That's a whole nother level. And I don't have kids, so I'm not thinking about that as well.
I would just say, like, on Anne-Marie's point, for reporters don't be afraid to enlist the support of your newsroom leadership. Just like if your laptop broke, you wouldn't feel obliged to go fix it yourself or take it to, Staples or whatever. If you're concerned about risks, that you're going to face because you're reporting, make sure your editor knows. Ask your editor or your newsroom management, what support can you give me? Here's what I'm concerned about. How can the station support me? Don't feel like you have to just deal with that kind of thing on your own.
Well, I
Well,
think that's oh, I don't know. Somebody else was going to
I
jump
was
in.
just going to say, I think we're at time, and we want to be respectful of everybody's time. But what a great discussion! I'm sure we could continue talking here for hours and still not exhaust the topic. Did anybody have anything else burning issue, burning question before we say our goodbyes? All right. Well, then, on behalf of the Committee on the Judiciary and the Media, we really thank everybody for being here. We thank our panelists for taking the time to prepare and present to this group. We know how busy everyone is, and we really appreciate you taking the time out of your busy days to join us.
I'd just like to join Howard in thanking everybody for the great presentation. It was really informative, and I smiled when Anne Marie was talking, because I had been in town government for about 30 years before I went on the court, and there were a couple times where we really welcomed the filing of a right to know request, but you can't go out and ask for it. So, but it does happen. So, and I do realize, Anne Marie, I may have misspoken earlier. I know you're at the New Hampshire Bulletin, so my apologies. But thanks to all of you for making the time. It was really a great set of presentations, and thank you for all that, everybody on this. Thanks for all that you do. The fourth estate and the health of the fourth estate is vital to the functioning of democracy. So thanks to the lawyers, thanks to the reporters, thanks Howard, and thanks for joining us.